Hello, this is Matt on the Moon Lambeau channel, and look, I think it's time for these SEC attorneys that are litigating against Ripple to maybe consider a new career. The question is, where could they go though? I mean, I guess I would recommend that maybe they just start creating a bunch of Whoppers at Burger King, but I'm not confident they could really do a good job there. You know what I mean? So I'm not sure where to place them. But Ripple has yet another win. Oh yes, indeed, the judge will see the secret William Hinman documents that the SEC has been trying to hide. And I kid you not, like the SEC, and you'll see as I go through this video, it's very clear that their tactic is to delay and attempt to hide key attempt to hide key information. Sorry, let me take a sip here. I don't know where that came from. Excuse me. Sorry, guys. So anyway, there's a recent legal filing that just happened. That well, okay, a little bit of the Rona here. Okay, I really don't know where that came from, but that's staying in. I do these in one take. Sorry, guys. Hey, you know what though? I leaned away from the mic. I feel like most of the YouTubers that I watch, when they all cough, and I get it, like we're humans, we cough sometimes, right? I feel like every other YouTuber I've ever listened to, they like lean into the mic, right, and right as they're coughing. Why does it have to be like that? This is why we can't have nice things. But look, but before I go any further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who likes to make YouTube videos where I cough a whole bunch and don't provide any value. That's pretty much it. So thanks for stopping by. And so look, here's the deal. The judge will personally see evidence that the SEC is trying to hide, and they don't want this evidence to see the light of day, but why? Well, because it's proof that the SEC told a third party, which was seeking advice from the SEC, to use the 2018 Bill Hinman Ethereum free pass speech as guidance. And this is highly relevant evidence. And it dramatically strengthens Ripple's fair notice defense, which is why I'm sitting here thinking these attorneys, they've got to get some sort of new career because what's happening here, it just ain't panning out, son. It's like this is not working out. And so just to set the table just a little bit here, this will be real quick, but I want to make sure everybody knows what we're talking about. There is a legal filing on September 24th, 2021, which is what's on your screen right here. And this is the bombshell. What was discovered here, because again, don't forget. Ripple has their fair notice defense, which is this idea that the Ripple just conducting their business in broad daylight for the better part of a decade, doing everything that would have been reasonably expected of them, from in terms of like what the SEC expects to make sure that you're not violating securities law or anything like it. They clearly were abiding by everything that was made publicly known in terms of how they're supposed to behave from a legal perspective. Ripple has, but then the SEC here. They're also claiming at the same time here that Bill Hinman's speech, where he basically said that he believes Ethereum is not a security, that was just his personal opinion, right? And so that's not guidance from the SEC, but now we're finding out that there actually is guidance here, that they were recommended that it gets used as guidance, and this just completely obliterates the SEC's position that Ripple did have sufficient regulatory clarity. It blows a hole through their argument here that the SEC, the position from the Bill Hinman speech was just Bill Hinman's position and not the SEC's. And so take a look at this. The court held oral argument on this motion on August 31st, 2021, and ordered the SEC to provide the court with the documents listed in Appendix A for in-camera inspection. 2 days after the hearing and the court's order on September 2nd, 2021, the SEC provided defendants with an 8th privilege log with 19 new entries. We respectfully request that the court add 3 of those new entries to the body of documents your honor will review in camera. And when they say in camera, that just means they want the judge to review in person specific documents having to do with Bitcoin, Ethereum, and XRP. And so the judge did order that all of these documents would be reviewed in camera because the SEC is claiming privilege, which means that these documents, nobody can see these. They're super duper mega secret, and it'd be dangerous. We can't let this get out into the public or anyone's eyes other than ours. So the judge is like, no. I'm going to look at this and I'll decide if that's true, if your privilege claims actually make sense here. And so she's going to review those. But here's the sneaky thing that the SEC did. After the judge ordered those documents be reviewed specifically by her, after they're doing everything they can to not allow that to happen, then we find out that there were additional documents that they just chose to not mention up to that point, which happened to seem to be highly consequential to the case. And then they knew that Ripple would have to file more documents to try and get the judge to review those as well. And there's a chance, even if it's a small one, that for some reason the judge would say no to that after saying yes, she would personally review the rest of the documents. So that's what they're doing, delaying and then hoping that there would be a different ruling on this. Hedging their bets effectively. Sneaky and terrible, right? I know. So check this out. Here's why this is a big deal. The descriptions of 3 of these documents from the belatedly produced privilege log suggest they may be highly relevant to this case. 2 relate to meetings the SEC had with law firms to discuss the unprecedented confusion in the market regarding the SEC's view on the status of digital assets under the federal securities law. And this is the big one. The third is an email chain concerning discussions with a third party whom defendants understand received guidance from the SEC to analyze its digital asset under the framework set forth in Director William Hinman's June 14th, 2018 speech. And so that's it. That's the money shot right there. The SEC, while claiming that Bill Hinman's speech is not official guidance from the SEC, told some third party who was seeking clarity in the space. They came to the SEC, this third party, and the SEC's like, oh yeah, here, Bill Hinman's speech, that's guidance, look at that. And so, look, if that's the case, I know, we're all just like, so why can't this damn thing just end already? Well, unfortunately, it's not how it works, but this is why I keep saying, like, there's so much evidence against the SEC, it just seems insurmountable. They're going to have to throw in the towel at some point, right? Don't you think at some point we're just going to, we'll wake up one morning and we'll just have the headlines of settlement? Doesn't that seem like the most likely outcome? I mean, yeah, there's a chance this thing's fully litigated, and I'm not ruling that out, but it just seems more likely one day we're just going to wake up. We don't know what day it's going to be, just a day that ends with the letter Y, and then bam, magical news. And I'll be happy to report on that. It's going to be a fantastic day. That's what is, I think, most likely to happen, but you don't know for sure. And so James K. Filan, he's been sharing these documents, and here's what he reported regarding the most recent development on this. Judge Netburn orders the SEC to submit for in-camera review, that just means in-person review, the 2 documents related to the SEC's meetings with the law firms and the email chain, ding ding, that's the big one, the William Hinman email chain, concerning discussions with a third party who received guidance from the SEC to analyze its digital asset under the framework set forth in Hinman's June 14th, 2018 speech. The SEC must also submit an explanation for its privilege assertions for all of those documents no later than October 15th, 2021. And the SEC must also file a redacted version of its submission on the public docket. Defendant's response is due no later than October 22nd, 2021. See, this is a big deal. This is another one of those things that just can end the case, effectively. And so here's how it was actually worded from the court here. This is from a Finance Feeds article. The breaking news here is that Judge Sarah Netburn has ruled in favor of Ripple's request and will be adding the documents and the email chain to the in-camera review. And here's how it was written. Defendant's request is granted. The SEC shall submit the 2 documents related to the SEC's meetings with the law firms, and the email chain for in-camera review, although along with a submission explaining its privilege assertions for each of those documents no later than October 15th, 2021. The SEC shall file a redacted version of its submission on the public docket. So there you go. Like it's coming here. This is astonishing. I know I think that everybody out there, like what I'm feeling, I believe that every single one of you listening, you're feeling the same thing too. How is this a case? right? How in the ever-loving hell can this possibly be a case here? Here, somebody had a question for attorney James Filan, XRP community member and attorney James Filan, and wrote, "Thank you, James," because he shared this information. Quick question. So they have to submit the 3 documents before the 15th, but have until the 22nd to dispute the request or the privilege, question mark. So either way, they have to submit them to the in-camera review, question mark. And James said, they have to submit the documents and the letter saying why they think they are privileged no later than October 15th. Then the Ripple defendants have to reply to the SEC letter by October 22nd, but the judge sees the documents no later than October 15th. So I'm sure we're going to be hearing more on this sooner than later. You know, it's less than a week away at this point. My gosh, what the hell were these asshats thinking when they filed this case against Ripple? Like, what in the ever-loving hell? You gotta wonder what the thought process was here. Now, given the sloppiness of this and the fact that it's a piss poor arguments from the SEC, you gotta kind of wonder. Like, Jay Clayton on his way out the door, like, he had to have known how poor this was, right? He just wanted to, like, light the building on fire on his way out, effectively, figuratively. Is that basically what he wanted to do for reasons that are unbeknownst to us? I don't know. All we can do is sit here and speculate, and that's all I'm doing here. I don't know. But it seems absurd to have this case in the first place, does it not? So there we are. That's the latest update here. I know it's the more I follow this and the more I see how this unfolds, like, the more offensive it gets when you see just how nonsensical all of this is. Like, I knew it was bad and stupid from the beginning, but just seeing every little detail unfold for the last nearly 10 months at this point, I don't see how the SEC could possibly win in a world where justice is served. But I'll go ahead and wrap up there. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.